Bharatiya Saksha Adhiniyam 2023. We have a guest speaker, Advocate G.K Naik Thigle. Sir is dedicated, resourceful and innovative legal professional having experience of 22 years in conducting arbitration, civil and criminal legal matters before High Court, Bombay Bench at Aurangabad, empaneled Standing Counsel for MTDC, MCB. Sir is additional government pleader and additional public prosecutor for High Court of Bombay Bench at Aurangabad from October 2013 to August 2015. Sir has vast experience of handling variety of approximately 3,000 criminal cases and more than approximately 4,000 civil cases of all types at High Court. Sir is a pioneer in handling various arbitration cases under Section 9, 11, 14, 34 and 37. Sir was been affiliated as a visiting lecturer for PG study in law at Babasaheb Ambedkar University, Aurangabad. Sir was appointed as judicial researcher to Honorable Justice Mr. P.V. Reddy in 2003 at Supreme Court of India. Sir's academic qualifications are: Sir has completed his masters from NLSIU Bangalore. Sir has completed his graduation from Symbiosis at Society's Law College, University of Pune. Sir's awards and achievements are: Sir has conducted field work at Kalada and Parvatgiri Village District, Warangal, Andhra Pradesh for partial fulfillment of research methodology. Sir has conducted national workshop on right to information organized by United Nations Development Programme and NLSIU 2002, presented research paper on maintenance of records and retention policy. Sir was researcher for National Training Session on Security Laws organized by National Law School of India, University and United Nations Development Programme 2003. Sir has published article in the Academy Law Review, Volume 27, 1 and 2 in 2003. Sir has delivered various lectures at the NLSIU Bhopal, Madhya Pradesh, Symbiosis International University, Pune. We're glad to have you, sir. Now I would request Ms. Reena Mandhani to felicitate us, sir. Thank you, sir. Thank you, ma'am. We are extremely grateful to have you, sir. We welcome you wholeheartedly and would request you to guide us about the new changes in old law of Indian Evidence Act.
Good evening, everybody. I hope you have enjoyed the earlier sessions, and by now you must have been. I don't know what's your status of mind, whether you are fresh, refreshed. I don't know what was served in the lunch, but let us hope that there was nothing which will have a kind of a different effect than to concentrate in the classroom. Initially, I had thought of preparing a kind of a brief note and circulate it to everybody so that you can easily try to see what exactly is the law of evidence and how the new law as far as the Bharatiya Saksha Adhiniyam 2023 is concerned, whether it's the same old wine in the new bottle, or it's a refurbishment of the earlier old products. That would be something altogether a different sphere. But may I request that the persons who are sitting behind it, there is no so special reason they can come in the front so that it would be kind of a compact thing. Can you come in the front? The last row, पुढे येता, so it is easier. So normally when you talk of evidence, the evidence is normally considered as proving something. So we are to talk about what do you mean by proving something, or what exactly is the evidence that you call it to be. So epistemologically, if you try to consider the various aspects of the evidence as such, the that remote. So if we try to analyze what exactly is the law of evidence, before we proceed further, it would be interesting to note that the word evidence, how it has evolved. Anybody who has studied evidence prior to today's orientation, or I can call it as a kind of introductory session? If not, then it's worthwhile to note that the evolution of this word evidence, or epistemologically what we call it as, it has its origin in the Latin term. That Latin term means, or it is pronounced as evidence or evider. So evider in the Latin term would mean that to show something clearly, to demonstrate something clearly, or to give a complete sight of, a clear sight, clear to the sight. So that is what is the word evidence that has come into the foreplay. Now, the word evidence, if we consider from various angles, so it changes its various perspectives. We'll have a quick session. So, what's your good name, sir? What's your good name? The middleman. White color, yeah? Aditya. So, Aditya, I ask you a simple question. And that question is very sure. Do you know what is the time now? Do you know what is the time? 3? What is the time? Do you know what is the time? 3? 3:51. Okay. 3? 3 p.m. Okay. So this is the answer that he has given. The same question was asked by the lawyer of Bill Clinton. Who was Bill Clinton? Nobody knows it? No? Clinton? No. Nobody knows it. Clinton was one of the presidents of US. Yes?
Former American president.
Yes, former American president. And there was a famous or infamous trial at Lewinsky trial, Monica Lewinsky trial against Bill Clinton. And that went on for a long. And unlike Indian system, the lawyers over there have a very interesting and long interacting sessions with the client. That is to just find out what exactly is the crux of the matter. And the question that was being always told by the lawyer that to Hillary Clinton and Bill Clinton, that please be careful, because the questions would be very harsh against you, which would be put by the other side. So they said that we have run the country. What you are trying to tell us? You are just a small lawyer. You are trying to teach us what should be answered in the court. He said you need to be very careful. He said that I'll give you one demonstration. I'll ask you one question. Do you know what is the time? And that gentleman answered that it is 3 p.m. He said it's a foolish answer. It's a wrong answer. It is a correct answer in common law, common sense perspective, but it's a wrong answer if you are in the court. He said, how come? I asked you, what is the? Do you know what is the time? The answer should be yes or no. The answer should be yes or no. Yes, I know what is the time. So that is how is the word evidence or the word evidence that has come in place. So this will give you a slight idea as to how important role the entire Evidence Act plays when it comes to a trial or establishing something in the four corners of the code. Though I was academician earlier point of time, or I tried to be academician, but I am more on a professional side. So I need to bring it to your notice as to what are the various complex issues on the theoretical side as well as the practical side. We don't take it otherwise. This was just to illustrate that how it is difficult to pursue what exactly is the question and what should be the model answer to it. So it is all, is it? So the next question, what exactly is the Evidence Act meant for? So we have seen how the applicability or the functionality of this Evidence Act is tested or it is practiced in the courts of law. But what exactly is the role of Evidence Act? Yes? Anybody? Proving the crime. Okay, that could be one answer. Yes? Yes? Anything? Any guess? Okay, it is proving a crime or it will lead to proving a particular conclusion. Okay, that is again a good answer. Yes? Anybody from this side?
Give a clear clarification about that particular.
Okay, so that is making it clear. Okay, good. Otherwise, it should not happen that the English movie goes on and after everybody finishes his laughter, you start laughing. असं होत नाही ना, पिक्चर काय चालू आहे तर कळत नाही, सगळ्यांचं हसणं झाल्यानंतर आपल्याला हसू येतं, असं होत नाही. So, only when there is a silence, only two possibilities are there. You are not clear or everything is clear. So I hope it is on the later side. Okay. So the basic or the object of the Evidence Act is to make something clear in the courts of law. So you need not prove your evidence in a public debate. You can only show that this is the evidence that I have. But the credibility of that evidence, as the discussion was going on in the criminal cases involving the offense against the woman, that the cases will go on. They are in a public domain, but that would be proved or disproved only in the court. So that is how the importance of proving something in law. Now, before we proceed further, let us try to understand what exactly is the classification of law. Where do we put this evidence in? The Evidence Act needs to be put into which category? So, as you know, there are two types of law. I have deliberately made it as a horizontal scope. It's a public law and private law. Any example of private law? Say Indian Contract Act, Consumer Protection Act, Torts Act. Then you have other enactments which cover the relationship between two individuals. Two individuals. Then what exactly is the public law? Public, private law is the same law. Contract Act is applicable to everybody. No, but it has a universal application. Only because you have entered into contract with B person and B has entered into contract with C person, the applicability of law would be same for all three. So what's the example of public law? Tax law is again a private law. To a certain extent, yes, there is an element of public law. Constitutional law, that's a good answer. So it is essentially, to cut it short, essentially the public law would govern the relationship of citizen with the state machinery. Therefore, I said to a certain extent, tax law is a public law. So it is regulating your relationship with the state machinery. State machinery meaning thereby a state legislature, state or the central legislation. So the private law would definitely provide for the relationship inter say the two individuals. It has its universal applicability. So the private law and the public law, these are the two components. So where do we put Evidence Act into? So it's essentially a private law because it applies to everybody in a clear manner. But there is an element of public law in it. How do you confuse with that? So because the state, any criminal moment you say that you are into a criminal trial, criminal trials on the basis of FIR, they are essentially a state-driven trial. That is, the state has to prove everything beyond the reasonable doubt. So it's a duty of the state to protect its citizen. Though individual is affected by commission of that particular crime, it is the sole responsibility of a state to go ahead and prosecute the offender for that purpose. Therefore, there is a distinction between private law and a public law, and the evidence law, to a large extent, would form part of a private law. Then we again go ahead with the further classification. I think by now you must have gone through it. That is substantive law and a procedural law. So the procedural law would essentially mean a code of civil procedure, code of criminal procedure. It is more of a procedural driven. त्याची applicability as such काही नसते. त्याचा फक्त utilization हे court work साठी असते. So that is a procedural law. The example of procedural law in criminal law is CRPC, whereas if it is concerning the civil case, it is CPC. So these are the two broad classifications of the various laws, and then we move on to the next slide. So this is what is the component of Evidence Act. Now before we move further, the concept of Evidence Act, to give, because the session in one session, एका सेशन मध्ये तुम्हाला सगळा एव्हिडन्स ऍक्ट समजू शकत नाही, त्याच्यातलं एक सेक्शन सुद्धा समजू शकत नाही. This is very clear to at least to me. So I am not going to undertake that Herculean task of explaining each and every section to you. आजच्या लेक्चर्स ऑफ किंवा आजच्या डिस्कोर्सचा एवढाच लिमिटेड पर्पज आहे that we are exposed to the various aspects of Evidence Act, and the basic principle of Evidence Act, that should be clear to you. That is what, if this much of goal is achieved today, I think it would be a great success, because it is very difficult even for the lawyers to understand what exactly is the role of Evidence Act in the day-to-day functioning of the court, because याची कुठली direct applicability कोर्टामध्ये येत नाही unless and until the particular person is put to a trial, he is into the witness box, and then you proceed further. So considering these kind of intricacies of the Evidence Act, it is very important to have at least first glimpses of the Evidence Act, so to explain it properly, to have a bird's eye view. तर त्याच्यामध्ये आपण जेव्हा वरतून पाहतो तेव्हा आपल्याला थोडंसं लक्षात येईल की exactly how Evidence Act is structured, what exactly is the structure of Evidence Act, and then only you will be able to understand the various niceties of this Evidence Act. So depending upon the classification of various legal systems across the world, the concept of Evidence Act undergoes a change. So what are the different systems of legal systems, legal regimes in the world which can be classified? Anybody has an answer? So take an example. Indian legal system belongs to which class of legal regime? Common law legal regime. Anybody is aware as to what exactly is the common law? Yes, what is it? Yes.
Where Britishers ruled.
Yes. Good answer.
Commonwealth countries.
Commonwealth countries. Okay. Yes. Next. What do you mean by common law? Yes, please.
Law created by judges.
No, that is not common law. That may be common sense law. That may not be common law. Your answer is right to certain extent. Yes. Yes, the last bench, last 3-4 bench. What do you mean by common law? Okay. Yes, please.
The laws imposed by Englishmen over the countries which they ruled.
Okay. So, common law to a rudimentary extent, I'll just immediately demonstrate to you, try to explain it to you. The common law legal regime is a kind of a adversarial legal regime, though we try to, or we tend to identify the common law from a historical perspective. The British and common law countries, it is a different yardstick altogether. The common law is called because it is based on an adversarial legal system. Now, what do you mean by adversarial legal system? Adversarial legal system, if you try to epistemologically dissect it, so it has adversaries in it. So there are two persons posing rival claims against each other. Therefore, it is called as an adversarial legal system. So this adversarial legal system, the Evidence Act has a greater role to play. If you go to other civil legal regime, or we call it as a continental legal regime, because you, in today's 21st century, you cannot restrict yourself to a particular nation. You have to definitely think of what is happening in a contemporary world. So it is very important for you to note that what are the other prevalent legal systems in world. So the civil or continental legal system, take an example of Germany, take an example of France, take an example of any other European countries which are non-common or non-adversarial legal system. So the role of court is not to decide what is projected before it, but the role of court is to also investigate. So they have more or less a settlement oriented legal system. It's a settlement oriented legal system, whereas the common law legal systems are decision oriented legal systems. So you are just adjudicating, giving a decision. If justice happens, it happens as a byproduct. These are not justice oriented legal systems. So this should be very clear. So most of the time you think that courts are courts of justice. No, that's the wrong answer. The courts are courts of law, where law is discussed and decision is rendered. If justice is delivered as a byproduct, they do not have any objection. But it is definitely not a system which is meant for delivery of a justice. So we call it as a justice dispensation system. We do not call it as a justice delivery system. So justice gets dispensed. So this is essentially a court of law. And you have a third legal system, that is socialist kind of a legal system. We need not dwell upon it much now. But it is suffice to say that as far as the adversarial legal system is concerned, the Evidence Act has a great role to play, and the role can be categorized as a civil role, and you need to keep in mind this important legal word. Can anybody read what is written on the second line here? What is written here? Yes.
Preponderance of probability.
And what is written here? Yes. So this basic distinction you should always keep in mind, that moment you call any case to be a civil case, and if you have to understand the Evidence Act in the civil case, you have to consider that what is role of the party going to the court is to prove that his or her case is established on the basis of preponderance of probabilities. If you are going to a civil court, and if it's a criminal trial, what's the word? Burden of proof. So what's the difference between preponderance of probabilities and burden of proof? I'll demonstrate in a minute. Burden of proof in a criminal case will never shift on the accused unless he pleads alibi or some special kind of defenses, which require that it should be proved by accused by leading up appropriate evidence. What do you mean by alibi? See, there was a murder committed on a rail track, and some person is made accused of that murder. He says that I was not on the rail track, I was attending MGM symposium or this function today. And he tries to make a plea of alibi. So he would provide CCTV footage or the camera footage. Then you have CCTV outside the parking. You have a attendance register where you have signed. So this is how the plea of alibi. So it is on you to demonstrate that you are not there. So except for these 2-3 categories, the burden of proof would be always on the prosecution. So burden of proof never changes when it comes to a criminal trial. Now, between these civil and criminal, there is third category. I have purposefully not mentioned it because it would lead to an unnecessary confusion. The third category is election trials. So the elections of MP and MLA, if they are to be challenged somewhere, they are challenged in which court? Any guess? Yes? In which court that would be challenged? Not in the court. Supreme Court, okay. Trial court, yes. Any other court?
Election tribunal.
Elections of Lok Sabha, Rajya Sabha, Vidhan Sabha, Vidhan Parishad. High Court. Under what section? Is Article 329. Yes? So this is what is a constitutional provision. I hope you have studied constitution by now. No? No, you're in second year, right? First year, okay. You haven't done it in your CLAT examination or no? Central entrance test. Constitution was there. Okay. But everybody has passed without studying constitution. On a lighter note. Okay. So this is the broad distinction between civil and criminal act. Now just we'll try to finish it in another 5-10 minutes. 5 minutes maximum. The object of Indian Evidence Act, as it was prevailing earlier, the object of Indian Evidence Act, can anybody read it for me? Anybody can stand up and read it, so everybody can hear it. You want to use my mic? Please come. Tell a mic there.
Hello, hello.
Yes, hello, we can hear you.
Object of Indian Evidence Act to prevent laxity in the administrability of evidence and to introduce a more correct and uniform rule of practice than was prevalent. The Act is not intended to do more than prescribe rules for the administrability or otherwise of evidence on the issues as to which court have to record findings.
Yes. So quickly we'll try to identify three important words in it. So the first is admissibility of evidence. Then the second word that you will definitely try to understand is after this admissibility of the evidence, you'll find evidence on issues. As we were trying to discuss that this is an adversarial legal system, so two persons will fight with each other, not physically, but in the court. And if they have certain litigation against each other, rival claims against each other, how are they settled? So one claims that he is owner of XYZ immobile property, other says he is also owner of this XYZ immobile property. So the issue would be who is that owner of the property. So on that issue, whatever evidence is laid, that is called as evidence on issue. This you will try to get it when you go gradually try to study the civil procedure code, where what is meant by issues, what is meant by the finding on the issue, that would be discussed. Whereas the next object of BSA 2023 is an act to consolidate and to provide for general rules and principles of evidence for fair trial. So for the first time from the British era, which wanted you to have an evidence act which would provide for adjudication of the rival dispute, has changed its course. And now what is meant or what is stated is that principles of evidence for fair trial. So fair trial and principles of evidence, these are the two keynotes which have been introduced as far as BSA 2023 is concerned. Now before we proceed further, can anybody read it aloud, that same thing? Mike Punagade. Okay. Please pass on to the next slide. Yes. You can just read it first. That is, evidence must be confined to matter in
Issue.
Then the next, hearsay evidence must be excluded. What is written is hearsay. And the third is that the best evidence should be adduced. So these are the three basic principles flowing from the Evidence Act, which to a large extent are also available in the Evidence Act that we have it now. So how does this new Bharatiya Adhiniyam looks like? So this is basically divided into 12 chapters with 170 sections. The 12 sections or 12 chapters are broadly based on the same scheme of the repealed act. There is only change of the name. So as we were trying to say that old wine in a new bottle, so I have used a better word, old product in the new wrapping. Okay, that suits the legal journalism. Otherwise the wine doesn't suit legal profession. So the refurbishment is not a reformation. So if you have any kind of a misunderstanding or an impression that the new acts have come into place, you will definitely read it now. Read the next sentence. After refurbishment,
not the institution but the approach of individual affect the system.
So this is what is again a statement, because everybody was trying to say that the legal system or the Indian Evidence Act or the Indian Criminal Procedure Code, they are so faulty that the trials and the court works, they keep on dragged for years together, and one generation is always excluded from the fruits of the litigation that it has started. So it's a generational kind of a feeling that was being given. But this was an opportunity for the legislature to have a clear picture about the Evidence Act, or to have reformation in the Indian Evidence Act. But unfortunately, that has not happened. What has happened is only it's a refurbishment of whatever that was available. Maybe the amendments like Section 65B that was prevalent in the old Evidence Act. It provided for leading of electronic evidence or proving certain electronic document by virtue of a certificate of the proof by the author. That was 65B. That is now changed to Section 63 because 65B was not looking proper, because it was introduced later. So those amendments and everything that has been consolidated, and now the sections those are rearranged or the same scheme but with little bit of a change on the title, but the section, the body, or the specific intent of those sections, that is the same. Now, as we have tried to understand the distinction between adjudication and the justice, justice is never an aim of the legal systems, those are prevalent worldwide. What is the aim is to adjudicate and render a decision. That's the end of it. So this is how the various sections are arranged, rearranged. Because as I said, that this is not a kind of a opportunity that we will be able to cover each and every section of the Indian Evidence Act or the Bharatiya Saksha Sanhita. But these are some of the chapters and the other important the scheme of the act. That is how it has gone into. And while dealing with each and every sections, you will definitely have an opportunity to understand the various niceties of admissibility of the document, issues, burden of proof, and preponderance of probabilities. Now, we will stop here with a small discussion on the truth versus the proved facts. The discussion is truth versus proved facts. And I want everybody to participate in this discussion for the reason that that is how the lawyer's mind should work. Merely because you have taken admission in a law course, that does not give you monopoly over the legal knowledge. Barabar hai? Merely because you are a law student, that will not give you monopoly over the legal knowledge. Any other layman who goes to a bookshop, reads the law, he is thorough with the understanding, who is able to comprehend what is written in the book. He can definitely know law, even at times better than lawyers. But what is the aim of the law course? The aim of law course is to build or cultivate an analytical mind. That analytical mind cannot be built in a one day or in one reading of a small book. It will take its own process, and the role of your classmates, role of your friends, that play an important role in classroom, not outside classroom. In classroom, what you discuss amongst yourself, with your teacher, with your coordinator, that would shape your analytical mind, that would build or enhance your analytical mind, how you think, how do you apply the story that is being told to you by your client, and how do you try to fit it best in the available legal regime. That is the role of lawyer, that is the main function of lawyer that he plays in the legal system. So with this, we will try to discuss what do you mean by truth, and whether the Evidence Act has object of telling out the truth. Evidence Actचं ऑब्जेक्ट हे सत्य जाणण्याचं आहे. त्या एव्हिडन्स ऍक्टचं ऑब्जेक्ट हे फक्त फॅक्ट्स प्रूव्ह करण्याचं आहे. याच्यावरती आय वॉन्ट एव्हरीबडी टू पार्टिसिपेट अँड गिव्ह हिज ओपिनियन. येस जेंटलमॅन, फ्रॉम यू, व्हॉट यू मीन बाय ट्रूथ? विल ट्राय टू मेक इट सिम्पल. व्हॉट यू मीन बाय ट्रूथ? Yes?
An act or object that has been really happened.
Okay. That is what has happened. Okay. That is fact. Why it happened? That will be truth. Okay. Yes. What do you mean by truth? Marathi Tamil is
Such.
okay. So it's a translation of Marathi words into English. That's okay. Okay. Yes. Next. Yes. Okay, that is good answer. The thing which is not false is truth. Please give a good answer. That's thinking like a lawyer. Yes. Yes? Okay, what is proved in the court is a proved fact. And what? Okay. So truth and proved facts are different. Okay. That's again a good answer. So we are driving gradually at the fag end. So one more improvement. So whether there is only single truth or multiple truths? Multiple. Why do you say that? Multiple facts. Okay. But multiple facts did not necessarily lead to multiple truths. Facts are different than truth. Proved facts would be different. Yes? तुमच्याशीच बोलतोय मी. Yes. What do you mean by truth? सत्य म्हणजे काय? Don't take the names of movies. Okay. So truth is essentially a discovery. This is one of the definition. It is not a universal definition. Because this is something on which there is a lot of literature you will find. What is truth and what is not truth. So truth is essentially a discovered fact which is accepted by everybody. So to give you an example of truth, that there is a sun, there is a moon. So you may change its nomenclature, you may have your own beliefs in that, but the fact remains that the sun and moon, they are available. So this is a truth. So you may call it, or you may term it in different language, different connotations, and different modalities. But what is your good name? Vedant. So Vedant has seen sun in the morning, and after seeing sun, he started going to the college. This is a proved fact related to the truth. So Vedant is aware that the sun has arisen. Did you see it? Anyhow today? पाहिलं का सूर्य उगवलेला? या सूर्य उगवल्यानंतर तुम्ही उगवले. So this is how the correlation between truth and proved fact. This is how it will happen. So object of today's discussion was not to make you aware and not to memorize you various sections of the Bharatiya Saksha Adhiniyam, but the today's purpose was to bring it home that there is something called as evidence. What does the evidence mean? Where from the word evidence has come? What was the law prevalent prior to this particular act? बरोबर मला वाटतं सगळ्यांना बऱ्यापैकी माहित झालं आता. झालं ना माहित? Because I couldn't hear. Okay. So this was a kind of a orientation that you have received. So there are 2-3 important words which relate to Evidence Act. And what is that? Can anybody? Yes? Classification. The burden of proof. Then preponderance of probability. Then evidence relating to issues. Admissibility of evidence. Proved facts. So these are some of the key words that I think you have understood, or you are taking it home along with you. बरोबर आहे ना? हे सगळ्यांना समजलं ना? Okay. So even if this is achieved, I think the purpose of the today's discourse will be well achieved. Now we go back to the same discussion, because we have completed only first part of the later part. That is, what do you mean by proved facts? Now the proof of a particular fact As you have gone to the court, the issue is framed and the evidence is laid on these particular facts, and that gets proved in the court. And where does it get reflected? In the findings of the court. In the findings of the court. So the admissible evidence established through proved facts and culminating into the final decision or final verdict or final conclusion of the court. That is how the Evidence Act would have its own journey from scratch to end. I think this was the important areas. These are the important areas which you should definitely note down. That these are the important areas where you will have a great applicability of the Evidence Act in the days to come. The first and the foremost important area is something called as digital arrest. Everybody must have come to the got to know that in the recent days, this particular dangerous trend of digital arrest is very much prevalent, wherein somebody calls you posing that he or she is a policeman and you have committed some crime, and this is what is the amount that he or she would demand from you. And in that entire sequence, your mindset would be so hampered that you will be digitally arrested. You would not be able to do anything. The person would be sitting somewhere in other countries like France, Dubai, Abu Dhabi, or say Germany, and he'll be controlling you. He'll be controlling your mindset. You would be controlling your financial activities. That is how it is called as digital arrest. Then the second is Bitcoin. People have started using or trading in Bitcoin. Various transactions are happening in terms of the international trade, in terms of the common parlance. Those are happening in Bitcoin. How do you go ahead with it? Where do you prove it? How do you prove that these Bitcoins have been received? Or you have been duped for these many Bitcoins? The currency has changed. The next is the blog writing. Somebody writes a blog against someone else and commits a defamation. So somebody is defamed, somebody's image is tarnished. How do you go with the evidence? How do you prove it? So these are all the various aspects of the Evidence Act that would definitely be required to be explored in your next days to come. And I am sure that with this kind of a innovative bent of legal mind, you will definitely cultivate an analytical thinking pattern, and you should definitely find difference in yourself when you join the course of law, and at the time of passing or taking away your legal degree, there should be some change in your thinking pattern. And if that positive change happens, then only you should think that the legal education, there is a success, or the legal education has given you some contribution in your life. So it is, before you contribute to the legal system, there should be contribution to your own personality. There should be contribution for your own reformation. That is the basis, or that is the object of the legal course. बरोबर आहे. शिक्षण झालं तर झालं, पण मानसिक आपलं त्याच्यामध्ये डेव्हलपमेंट झाली पाहिजे, किंवा त्याच्यामध्ये प्रगती झाली पाहिजे, विचारांची प्रगती झाली पाहिजे. हा या लॉ कोर्सचा इतर शैक्षणिक उद्दिष्ट जशी असतात तशीच या कायद्याच्या शिक्षणाची पण हीच उद्दिष्ट आहेत. So I think you will always keep this in mind, and I wish everybody all the best, and if anybody has any comments or questions, I am open for it. I thank the organizers, Professor Mandani Madam, for inviting me for this interactive session, and it was pleasure meeting everybody else. In case you have any doubts, you can always reach out to me. My email ID is courtclient, COURTCLIENT @gmail.com. You can always reach to me. I'll be happy to respond to any of the queries relating to the legal matter. Thank you. Scot free. Yes. The answer to it is very clear. The earlier Evidence Act, if you try to refer to the earlier slides, what is the year of this Evidence Act? 1872. So, do you have any single monument in your house which dates back to this date? इतकं जुनं काहीच नाहीये, पण हा एव्हिडन्स ऍक्ट आजही 2024 मध्ये सुद्धा with little bit of variation, the same Indian Evidence Act is catering the needs. The problem is not with the act. Problem is with the people who are running that act. So therefore, I said in one of the slides that the problem is not with the law. Problem is with the approach of the person. Or even problem is not with the person, is approach. Therefore, the object of the education is to change your approach. माणूस कधीच वाईट नसतो, माणसाचे विचार आणि माणसाच्या सवयी वाईट असतात. ते जर माणसाचे वाईट विचार आणि वाईट सवयी गेल्या तर तो माणूस चांगला होतो. So even if you have dislike against some person, somebody, some friend, some other person in the class, then that problem is not with that particular person, it is problem with his thinking pattern. So you remove that thinking pattern, that person would be reformed person. Thinking pattern creates the person, it's a vicious circle. So if you want to break it, you have to read it. So more and more reading into the law would improve your thinking pattern. That's a clear answer. Yes? Any other comments, queries? From last bench, red shirt. Okay. I hope it was a good English movie. Yes? Okay. So the one who laughs last is going to be a victim. I hope everybody got clarity as to the basic principles of the Evidence Act, and I look forward for many other events, occasions to meet you in future also. Thank you very much.
Thank you so much, sir. That was a wonderful session. You explained us the Bharatiya Saksha Adhiniyam in simple manner and also explained the key words such as alibi, proof facts, truth, and etc. And as sir said that there are no substantial changes have been made in this law as the sections just no repetition has been made to the laws. It has only been a more synchronized manner. Am I correct, sir? And sir also told the areas of interest in evidence. Thank you so much, sir. It was honor to have you. And yes, it was a good English movie, sir. We laughed at the same time. There will be a 5 minutes tea break. You can have your tea and quickly come back here. We'll be having a third session of your favorite sir. Chaitanya Dharukar sir will be taking a next session.